Hello, welcome back. This is your host, Dr. Tulipo Mwenfumbo, taking you in labor law for paralegal counselors. Today, we are going to look at the law relating workers' wages. So, in the labor law, the other critical thing is knowing the how to reconcile the workers and the employers on issues relating to workers' wages. There are laws that governs that in Zambia. Like in Zambia, there are regulations on work and wages. The first one that we can look at it is the Employment Code Act 2019. It stipulates the wages for the workers. Then we have got the minimum wages and conditions of employment, General Order 2011, which was amended in also 2012. Then we have got minimum wages and conditions of employment, shop workers, Order 2011, amended also in 2012. Then we have got also minimum wages and conditions of employment, domestic workers, Order 2011, and it was also amended in 2012. So now, the minimum wage is defined as the minimum wages and conditions of employment, General Order 2011 defines minimum wages as the lowest wage that may be paid to an employee, while the minimum wages and conditions of employment, Domestic Workers Order 2011 defines minimum wages as the lowest wage which may be paid to a domestic workers. So I want us to look at this definition critically. According to the General Order 2011, it defines the minimum wage as the lowest wage that may be paid to an employee. And the order 2011 defines minimum wages as that is the minimum wages for domestic workers as the lowest wages which may be paid to a domestic worker. So now I want us to know, according to the laws of Zambia, that the Minister of Labor or the Labor Minister has got the powers to prescribe or to give direction on the minimum wages. So the Minister of Labor may prescribe wage rates for different categories of workers in an employment through a statutory order, if he or she is of opinion that there is no other effective way of regulating the minimum wages or working condition for those groups, especially in the absence of the collective agreement. So there is what is called collective agreement. I think we are going to talk about this. Now, the minimum wage, the minister has got the powers to determine the minimum wage in a certain sector or in a certain for the certain employment or the position in the labor market. So where the minister sees that there is no collective agreement or there is no condition that has been set to protect the workers, so the minister has got the rights to do that. I think we saw this in order which the minister gave the order in 2011, where the minister had to give the order and give the definition of the minimum wage according to the time at that time. So he looked at it, and at that time when the PF just came into government, it realizes that there were a lot of challenges when it comes to the payment of wages. And if you can remember, that is when the wages of the the civil servants were increased to 100%, and also the domestic workers were given the minimum wage by the minister, and anyone who obligated that was answerable to court. And that stands. What happens is that when the minister declares the minimum wage, and you as the employer or you obligate that, that means that if those workers go to court, they may claim the money that you have not paid them according to the minimum wage. So pursuant of this provision, Minister of Labour has issues three different statutory instruments. This is in the Employment Act, where the Act gives the powers to the minister to issue what is called the statutory instrument. The statutory instrument, it is in what is called administrative law, where the minister can declare and the minister can say the words of the minister can become the law. Like where the minister can say banning us of something, he may say no selling of this, or you have to put on the face mask. That becomes the law. So it is with a minimum wage. So the powers that have been given to the Minister of Labor is that he may, at his will, declare through the what is called the instrument, statutory instrument. It may declare the minimum wage and conditions of employment, general order. Like we have seen this in 2011, as I said, the minimum wages and the conditions of employment for shopkeepers, and also the minimum wages and conditions of employment for domestic workers. So the minister had to come in and also announces the minimum wages for the domestic workers and also the minimum wage for the shopkeepers. Order 2011 sets minimum wages and working conditions for certain employment groups. These statutory orders were first amended in 2012 and now in 2018, whereby the minimum wage rates have been increased. So the total minimum wage includes allowances like transport allowance, lunch allowance, housing allowance. All of these allowances are specified in this order, and also by different statutory orders, which is wage order. So according to the Employment Code Act of 2019 has repealed the minimum wages and conditions of employment act. The new law provides the Labour Advisory Committee, an ad hoc committee of the tripartite Consultative Labour Council. Now, this, according to the Employment Code Act of 2019, here now it has enacted where the conditions of employment can be set by what is called the advisory board. So the advisory board is set, and whereby there is what is called the tripartite consultative labor council. So they create the council, which comes from the ministry, from the government, then from the employers, and also from the employees, workers. So the union, the government, and the employers. So then they form up a committee and they begin to decide how the minimum wage should be, unlike whereby the minister dictates the minimum wage without knowing what is on the ground on the labor. For example, the challenges that we had in the 2011, where the government or the minister announced the minimum wage, and the employers had no option but to increase the prices of commodities. For example, when we looked at where there was the declaration on the minimum wage of shopkeepers. So we saw ShopLite and other stores in which who increase the price so that they may be able to accommodate those increments that were made. And same with the bakeries. So we saw the rising up of prices because of the market, the wage market, or the labor market, or the wage was increased. So the employers had no option because they cannot continue they cannot start paying the workers huge amounts whilst they are making losses. So they had to increase the prices. Now, in the Code of Acts 2019, it observed that and they repealed. And that is where now they had to set up the 3-in-1 council, where consultative labor council, where it contains uh, the government, the employers, and also the worker organizations like the union, the unions, the government, and also the employer. So in such a way, it may somehow balance up because they will be able to consider the needs and the needs of the employers and also the needs of the employees, and the government is able to have that consultative and give direction to those employers and the workers. There must also be two persons with knowledge and experience in determination of minimum wages and conditions of employment. So the committee must also include a representative of the national institution responsible for statistics. So there is also that committee also they invite or they include someone who is on statistical who understands the statistics or the economy or nouveau employment. So they determine if we can be able to increase the wages, what will be the impact on the economy. You know, one thing that I've seen about the wage increment, the wage increment has got no favor or doesn't help in any way to the workers because unless if it is 100% as it was whereby the civil servants are given. But generally what happens is that the more the when the wages increases, also the prices increases. As a result, you find that the workers don't improve in any way in their wages. But the law states that that there must be a committee or a tripartite committee which should be able to determine how the wages should be made. So the Labor Advisory Committee may inquire into the wages and conditions of employment in any undertaking or sector in order to recommend minimum wages and conditions of employment, and review at least every 2 years and make recommendations to the minister on the minimum wages and conditions of employment for any group of employment. So what they do is that now it is enshrined by law that this committee has to consider and to research on the minimum wage, and they should also be able to advise the minister on how on that particular sector, how much they should be able to pay, and the effects on the economy. Because you know, labor market, it is very important in the employment, in the economy of the nation, because the labor force drives the economy again, because if the workers are not paid the wages that are which can sustain them, that means that even those people that are selling things in the community, they will be unable to sell because the people that are able to are supposed to buy cannot afford to buy. So that's where it calls that there must be a balancing of issues on this matter. So wages are supposed to be very cardinal in the employment law, because it should be able to balance up. It should be able to favor, because the law should be able to balance up the employers and the employees and bring harmony. And also, as on the definition, it should also bring dialogue between these two parties. So the procedures of making a statutory order regulating wages is not prescribed by the Minimum Wages and Conditions of Employment Act. However, the Act stipulates that the relevant trade union must be consulted before making any statutory order regarding a group of workers. So here the act stipulates that the minister or the people involved must make consultation before they make the declaration on the wage. So the procedures for making statutory order regulating wages is not prescribed by the minimum wages. So what we say, what it means is that the minimum wage does not prescribe how much should be paid, but that should come from the consultation that has to be made. Law does not impose any frequency of adjustment in minimum wage rates. So the minister from this act, it does not give the powers to the minister that he should be able to regulate or should impose the minimum wage as it happened in 2011. Now he has to take the consultative approach, and rather than whereby the minister just decides on that. So if the minister does give the minimum wage without consultations, then it means that that can be fought in court, and obviously the minister can lose the case. Now, this has come from, as I was saying, that in the 2011 challenge, when the minimum wage was announced by the minister. However, any person affected by a statutory order made under this section may apply to the minister for the review of such order. So when the minister gives the order on the minimum wage, and for example, as a sector, let's say he says the minimum wage for the shopkeepers should be this much. Then the affected, like the shopkeeper, those that runs the shop, they should write to the minister to review and give the reasons why the minister has been unfair in issuing such an order. So that if the minister may be able to review. In the case that the minister refuses to review it, then they can proceed by going into court. Currently, Labour office under the Ministry of Labour and Social Security does all the monitoring related to compliance with the law. So the Labour office is the one that enforces things like minimum wage. When the minister announces the minimum wage, the Labour office, through their inspectors, they also enforce this law. So the government, through the Ministry of Labour and Social Security, has a legal mandate to suspend the operating license of the defaulting entity. No compliance with the minimum wages and the conditions of employment act results in a fine of up to 2,000 units. When we say in the fine of 2,000 units, also there is also or imprisonment. So if anyone defaults, then the license can be withdrawn. Now, the challenge that I've seen in this, yes, the investors may be like they withdraw the license of the investors, but still the ones that suffers are the workers themselves. You see, the workers who were protesting, then the government through the Minister of Labor closes that company, and who is going to suffer? The workers still, they are going to suffer. So here there is no justice in this administration of wages. So we can see this in the sources like number 98 to 105 of the Employment Code of Acts 2009 of the minimum wages and conditions. So here it gives the general order 2011, the in 20 mandate 2012 2018 minimum wages. So these are the quotations that where we are what focuses on. I think you can just look at it, and I'll be able to post a screenshot on this one. Then there is also what is called the regular pay. In accordance with the Employment Code Act of 2019, an employer is under the obligation to pay the worker when due and payable on hourly, daily, fortnightly, monthly basis. The piece-rate employees have to be paid on the completion of the tasks. However, wages of piece rate, when we talk about the piece rate, we are talking about those workers who are doing piecework, where they have been given a task to complete. Now, in such, the law directs that the worker has to be paid immediately after he finishes the work. So they paid on the completion of their task. However, wages of piece rate, daily, hourly, employees can be accumulated and paid after a month. But if, for example, if the work is done just there, they can be paid. If agreed between the parties, the law requires payment of wages at regular intervals within 5 days on the completion of wage period for which wages are payable. So the law also puts it that workers must be paid within 5 days after the work has been accomplished. That is the work for the piecework. Now, also it applies to the normal work. So, if the month ends on 30th, so you have to be paid within 5 days. Wages are paid in legal tender directly to the employee or written on written request by check or postal order or money order or directly to the bank account. Wage payment can also be made to the person authorized by the employer in writing. So the wages, there is the definition on how the wages has to be paid to workers. In-kind payment, in addition to wages, is allowed. This payment is customary or agreed to by the employee or provided for in a collective agreement or in accordance with any written law, provided that any such payment, being an allowance in kind, shall be for the personal use and benefit of the employee and his family, and it must not be in the form of liquor or drugs. So there are also what is called wages in kind. So the law also gives whereby the employer uh, can appreciate the workers by giving them the wages in kind. Now, it forbids to give them wages in kind like a beer or drugs. So deduction from wages is allowed in case of contribution in any fund scheme approved by the minister, damage loss done by the worker, repayment of loan, and such other amounts as may be prescribed by the minister through statutory instrument. So there is also the law guides on how the deduction can be made for the workers. If the workers maybe has got debt, has gotten a loan, then it can be deducted, and or if there is a damage and the worker has to pay those damages, the worker the money can be deducted. So there is also the way that has to be prescribed, and there must be a written agreement, or there must be a written note whereby the employee has to be told, and it has to be certain and he has to agree to that. For example, if there is any damage that is caused, and according to the collective agreement, it states that any loss that the employee may cause to the company shall be deducted from his allowance. So in such a case, the employee should be written and told that your allowances or your salary is going to be affected, and there will be deduction on this reason. And same like there are also deducts whereby now that is done in the bank, whereby if your money enters, the employer may just give you the money, but if it enters into the bank, then the bank will be able to deduct from where you got the loans. So the employer must keep the record of wages and and deductions made from the wages. So this is very important to the workers or to the employers. They must keep the records, because even the labor officers, they can come for inspection on that. Or if there is any dispute on the account of the worker, then they can be able to produce that. So they are mandated to do that by law. An employer may not limit the right of the employee to dispose of his or her wages. An employer may establish a shop to sell provisions of workers. However, workers may not be compelled in any way to make purchases from the shop. Employer is required to explain to workers the wages and conditions on payment of wages of workers before commencement of employment. So this states that the employer must be able to tell or enlighten the workers, and also the employer can be able to give goods and products, even money on loan to the workers, but it has to be explained, and it should not be compelled. It must not be a must that when the employer, for example, is giving out minimum, which should be deducted from the salary, then it should not be imposed. The worker should decide whether to get that minimum or not. So the government of Zambia has promulgated Employment Code Act of 2019, which repeals and replaces the Employment Act 1967, the Employment Special Provisions Act 1966, the Employment Act of Young Persons and Children Act 1933, and the Minimum Wages and Conditions of Employment Act 1982. So these are the laws that governs the wages. So you can download them if you want to check on them. So you can download the Employment Code or Code Act of 2019. You can also download the 1965 Employment Act. You can also download the provisions of Act 1966 and Employment of Young Persons and Children Act 1933, and the Minimum Wages and Conditions of Employment Act 1982. Thank you so much. I believe that we have the statutory, we understand the statutory guideline on the minimum wages in Zambia. Thank you so much. Join me in the next class. This is your host, Dr. Tulipo Mwenfumbo, on wages of employment.